now for the legal beat on What She Said with Newberger and Partners LLP, plain talk about legal, liberty, and social justice issues that impact all Canadians, what we need to know and want to talk about. Today we're joined in studio by Joseph Newberger. Good to see you again.
Nice to see you too. Good morning.
And is there any other story to start with?
I don't think so.
No.
Go ahead.
Well, it's now in the hands of the jury, so the Forcillo trial is there, and we'll have to see what happens. It's extremely interesting. The justice then, who's an extremely experienced judge, gave very good instructions to the jury, and they're going to have to grapple with some very significant issues, but I still don't quite understand the murder versus the attempt murder charge and how they're going to work through it. But I think really what it comes down to is the judge has said, you have to consider whether the actions taken using the lethal force that the officer did was reasonable in the circumstances, and that whether he was acting in self-defense or self-preservation of himself or others. And what they're going to have to really, I think, grapple with is the second volley of shots. Mm-hmm. And also the evidence of the use of force expert, which talked about other de-escalation techniques which were not used, obviously, in this circumstance. Mr. Yatim was on the streetcar within close proximity to the officer, but not really in a position of hurting other civilians at that time. And it could be easy for a jury to conclude that in those circumstances he did not pose the imminent threat of serious bodily harm or death that maybe the defense is trying to make out quite strongly.
What about the things that the jury didn't hear, which is what everybody is
in that,
now?
yeah.
Well, is what everybody is talking about now.
Right.
And one of them, which is, Sharon, you mentioned it a minute ago, the number of times he, in the last 3.5 years,
has drawn his weapon.
Has drawn his weapon 12 times in 3.5 years.
Yeah.
And that he was being reviewed or up for review. And should that have been something admissible?
No. Some of it comes down to character evidence. So if he's being reviewed for certain other things, that's a type of character evidence which is generally inadmissible in a proceeding unless the defense themselves puts that into play. Drawing his weapon in 12 other instances, you literally have to examine all of those other instances and have the jury determine whether it's reasonable for him to have drawn his weapon in those other instances. So these will be 12 mini-trials, and it's what we call collateral in the business. So it would deflect from what happened. What's relevant is what was this officer's state of mind at the time that he was confronting and trying to deal with Mr. Yatim, and what were the observable actions which were going on that maybe make his conduct reasonable or not reasonable in the circumstances.
So there was also the theory of suicide by cop, which is the same deal. It's not the jury's issue what he was thinking.
Right. It's the officer's state of mind which is important, not Mr. Yatim's state of mind. It's clear that Mr. Yatim was not well as a result of taking the ecstasy. But whether he was trying to kill himself through a police officer shooting him or not is irrelevant for the jury to consider, and it's something that they should not hear.
Now, you're an extremely prominent criminal lawyer. In your
Thank you.
Expert opinion, you're welcome, and you know it.
Can you say that again?
I'll say it again, and you know it. In your expert opinion, how significant is this verdict going to be?
I think this is probably one of the most difficult cases that a jury had to deal with involving a shooting. And it's in a time and context now where this is front and center in the media, both in the United States and in Canada. Not so much here, but it is very prominent. So I think this is very significant. And the risk here is, if there is an acquittal, and I'm not making any judgment on it, there are those who may say that there is no protection of the public from reckless use of firearms by a police officer in a threatening situation. I'm not saying that that is the case, but I think that could be quite significant. There was 9 shots fired, 8 hit this gentleman. He was down on the ground during the second volley. I understand that the officer may be acting panicked and not thinking necessarily about wanting to kill, but it does seem close to a manslaughter to me. And it is a situation where it's not like this individual is on a public street with people all around and he's in such danger that he could just rush at him and others. It's more contained. So I think this is an extremely significant case, and this decision, I think, will be extremely significant.
I would imagine that whatever the verdict, there will be an appeal.
Probably, yes.
Probably?
Yeah.
And what other choices does the jury have in terms of finding him guilty of? Because he's been charged with...
It was charged with murder, so second-degree murder, attempted murder. Those are the two charges.
Right.
But
could they...
They could find a lesser offense of manslaughter.
Okay.
And as I've said, it's not my belief that this officer, based on all the evidence that we've heard, had an intention to kill. He may have fired 9 shots, but it's in a panicked moment in dealing with a very difficult crisis. So I think really the option for the jury is looking at this attempt murder, which is in relation to the second volley of shots, which I still don't understand, and then finding him not guilty of that. Then there would not be any other options other than maybe an aggravated assault, which wouldn't make sense to me either. So I really think it's second-degree murder or manslaughter, or they can find him guilty of the attempt murder.
Wow.
But ultimately for the Toronto Police Service, this is another learning process, and they have engaged a lot of resources to work on how to de-escalate these types of situations, and they're working hard on it. So this is significant for them, but significant, I think, for the public.
Yeah, and it also comes under sort of the microscope because of everything that's happened in the United States.
Everything that's happened in the United States, and dealing with people who either are on drugs which are causing them psychotic episodes, or people who are mentally unwell. And that is a prominent factor in our community, and unfortunately mental health is still not dealt with the way we need to deal with it.
And it's almost mental health on both sides of the coin, though. There's the mental health that precipitated the incident.
Yeah.
And I don't want necessarily say mental health, but a mental issue perhaps in a panic situation, which can escalate a situation to where we are now. So depending, what is the range of penalty that Officer Forcillo could be?
Well, if convicted of murder, then it's life imprisonment. Minimum parole is 10 years. If it's manslaughter, it can be anywhere from 0 to 10 years. I mean, there's a broad range, but you would have to take into consideration a number of factors. And for an attempt murder, it could be, again, 0 to a number of years in jail. So the life sentence is the one which is the most scariest.
Right.
But again, it's a situation where I just don't think a jury is going to find that this officer intended to kill him. I think this is a panicked situation where the officer's been on the service for 3 years, and it's frightening. And, I get that. Any human being, even if you're trained as a police officer, can be in one of those situations and still get panicked.
So, Joseph, moving on to one of your own cases, which has now been withdrawn.
Yeah, I was reading some articles about Crown assessments of cases. So generally in our process now, Crown's pre-screen cases, and then eventually as the case goes on, they assess it for reasonable prospect of conviction. And we were looking at some statistics, and I was looking at some statistics as to what this really results in. And I've had a number of cases that are withdrawn after what we call preliminary inquiry. And the person who's testifying, let's say it's a complainant, gets thoroughly cross-examined, and after that they assess the case and gets withdrawn. But the problem is a lot of this has been strung out, and I do a lot of work with domestic-related cases that come out of high-conflict divorces. And this one particular case has been going on for 3 years. And there are 2 children involved, and the parents have been in high conflict. And more than a year and a half ago, we completed a preliminary inquiry. And I'd been urging a proper review of the transcript, because I said even from an objective reading of it, there is absolutely no reasonable prospect of conviction. You could actually conclude that the complainant is fabricating, if not hadn't committed perjury. So on the eve of trial, and this is a big case that we're involved in, we're now getting notice that the charges will be stayed or withdrawn. And it really sort of, when I was looking at these statistics, and this happened yesterday, I'm looking at going, there needs to be a greater effort to have screening in place as the case progresses, to take a look at it. And you have to look at the damage that results from a prolonged proceeding like this.
3 years.
3 years is a long time.
Especially in a divorce situation where children are involved, and custody and visitation.
All sorts of agencies were involved, and all sorts of issues, and these children get damaged in the meantime. And if you really, I'm not saying all cases are like this, but where you have pretty good, clear evidence that the complainant in the case is not telling the truth, and this has been motivated to gain leverage in the other proceeding. And in our case, there was a marriage contract that they were trying to set aside, and it was very obvious what they were trying to do. there needs to be really proper screening so that people don't have to suffer like this. And it's for both, too. Whatever the motives of the complainant, which I don't condone, but that person suffers as well. So it was quite shocking to me, and I was looking at these statistics, and we're going to continue to take a look at what's being done for screening of these cases.
So that's really where it has to go, though, is the screening, because really your hands are tied on both sides of the argument.
Yeah, I mean, a lot of lawyers, you'll stand back and you sort of let the process play out. We don't. We run preliminary inquiries like trials. We really manage the case properly and continually to talk with the Crown and have a dialogue to try and get them to understand. I mean, we open our briefs to them sometimes to show them the evidence. So I think it's important that this type of dialogue goes on in more cases, and maybe less people will suffer from these types of instances where cases just go on for years and years and years.
Now, moving now to Calgary, and the Crown wanting a new murder trial for the woman who tossed newborns into the garbage.
Yeah, it's an awful case,
it's
right?
It's a despicable case, really.
Despicable.
It's horrible, and in my career I did two cases involving babies, and one of them was an infanticide, and I couldn't handle it afterward. But the Crown has argued, and quite interestingly, that the concept of infanticide, and it's an offense under the criminal code, so it's not a complete defense. In other words, they're found guilty and they get jail, but it is a phenomenon that a person who's charged with murder, a mother, could be found guilty of infanticide if they have a disturbed mind. And what they're arguing is this is very antiquated. There's no clear guidelines on what a disturbed mind is, and this woman should be set back for trial. Now, if you look at the facts, I mean, I think this is a clear murder case, but I don't have the benefit, and we don't have the benefit of the psychiatric assessment.
Right.
And if I can just say this, we have in law mental health defenses. So if somebody is suffering from a very pervasive mental illness like schizophrenia, and they're suffering severe delusions which impacted on their actions, so they didn't know that what they were doing was morally wrong, for example, they say the devil told them to do it, then they're found not guilty by reason of mental disorder, and then they go off to a mental health facility. If you still don't have enough for what we call that NCR defense, there still is a concept of diminished capacity, that their mind is still sufficiently ill and not operating well, that they may have a diminished responsibility for what they did, so they could be convicted of a lesser offense. That's sort of like what infanticide is, but it is very, it's very loosey-goosey. It's not...
Is it a postpartum depression argument?
Predominantly that's what it is. So in the two cases I had, it was postpartum depression, which actually had some psychotic features as well. So I wonder whether we need to bring this maybe into the 21st century and really look at it from the mental health standpoint, not called infanticide, and look at more of an expanded type of concept of not criminally responsible in these instances. But this is very horrific facts, and on its face when you read it, without having the benefit of the psychiatric reports, because there's a number of killings over time, one might imagine that this person is squarely committing murder. Horrible
Absolutely.
facts.
And again, speaking about a horrible situation, the Tim Bosma case, where jury selection, I mean, I don't know how much you can talk about this.
There's not much. I mean, the Crown, everybody's done a very good job to be rather tight-lipped about the evidence and the theory, which is what protects fair trials. But it's a case that's captured a lot of attention because of the main accused, Millard, who comes from that dynasty, and he's charged with 2 other murders. They reinvestigated the death of his father, so he's now charged with shooting his father and charged with the disappearance of the girl who was a girlfriend from, I believe that's 2012 as well. So he's facing 3 murder charges, and just his very nature as being sort of this adventurous playboy type of person, I think, has made it rather interesting. But it's an absolute tragedy, because if you think about how many times you advertise something on Kijiji or whatever, and people come to your door, this is a real tragedy.
It certainly raised the public awareness. It makes you really assess if you're going, because it's a great thing to be able to use something like Kijiji, but you do have to really be aware of your surroundings, who you're with, and where you're going. You
do, and statistically speaking, stranger homicides are very, very infrequent. So that makes this all the more sensational and terrifying.
Wow. Well, it's good to talk to you again, Joseph.
My
Great
pleasure.
To have you in, and,
thank you very much.
We'll look forward to talking some more about these cases as they go forward. That's today's Legal Beat, brought to you by Neuberger and Partners, LLP, one of Canada's leading criminal defense law firms, expertly defending clients since 1992. Visit them online at nrlawyers.com.
Click the channel subscribe button for full-length interviews and more from What She Said here on YouTube.